Right. Good afternoon, everyone, and thank you so much for joining the Global Environmental Law Centre's webinar. It is the 23rd of October, and we are really excited to host Dr. Abuye today. She will be presenting on climate change in Africa and environmental rule of law jurisprudence in the pursuit of environmental sustainability. Dr. Abuye is currently a sessional professor of law at the College of Law in the University of Saskatchewan in Canada. She is really well published, and her research interests focus on multi-dimensional exploration of the rule of law in Africa, touching on issues of good governance, legitimacy, and accountability. Prior to her current teaching engagement, Dr. Abuye was an associate professor of law at the University of South Africa for many years, during which time she served on multiple committees and structures in the university, including as editor-in-chief of the Comparative and International Law Journal of South Africa for 7 years. She is currently a co-rapporteur of the International Law Association Subcommittee on International Migration and International Law. The first interim report of the committee will serve at the 2024 ILA conference in Athens. Before I welcome or have Dr. Abuye share her slides, just some short housekeeping rules. We ask that everyone keeps their camera off during the presentation. At the end of the presentation, there is time for question and answers. But if you do have questions in the meantime, you're welcome to post it in the chat or in the Q&A session. But again, thanks everyone for joining. And Dr. Abuye, I give over to you. You can share your slides.
Thank you so much, Angela. Thank you, everyone. I first just want to thank the organizers of today's webinar. Thanks for the opportunity. The Global Environmental Law Center and the University of Western Cape Faculty of Law. So I will share my slide now. That was also just a test that I'm quite audible and you can all hear me. Okay. So yes, as Angela has kindly introduced, the topic of today's conversation, this webinar, is climate change in Africa. I'm just going to put off my video while doing that, just to ensure connection issues don't arise. So yes, the topic of today's webinar is climate change in Africa, an environmental rule of law jurisprudence in pursuit of environmental sustainability. And this paper was actually one that had come about as a result of certain other contributions and, just foray into the field of environmental law. I principally do research on rule of law issues and looking at different aspects of rule of law issues in Africa, and environmental law has been one that obviously has been topical. And so, yes, that's why this paper has come about. I'm just going to address this quickly and just a brief outline for us today. So just a quick background on global events that I'm sure we are very well aware of. Africa and its environmental protection mechanisms, the role of the judiciary in this environmental protection mechanisms, and then just charting, the jurisprudence and the development of environmental law, rule of law through jurisprudence in Africa, looking at where we started from, just a broad outlay, and looking at evolving considerations. The main focus is to see how the judiciary is able to use creative and proactive interpretations of law to ensure environmental protection. And then a quick look at some other jurisdictions also. And so what is all the issue about? When we look at the global environment and issues of climate change, we have different reports that continue to come out, most of them yearly, some come out every 2 years. but basically pointing our attention to the same thing, which is the changes to the climate change issues that we are having to face, the manifestation of climate change in terms of natural disasters, increasing in frequency and intensity all across the earth, the heating of the earth, we have rising sea levels, surface temperatures. So all of these are issues that continue to arise and continue to draw the attention of the world. And also, I must say, the efforts of the global community in trying to stem some of these natural changes that are occurring. So I've mentioned some of these reports on this slide. The main point of the reports from 2021, even to this present 2023, is that the mitigation efforts that the world has put in place are not fast or urgent enough because states continue to prevaricate when it comes to meeting their emissions targets. So that is a prevailing issue, that is a prevailing problem when it comes to the efforts that the world is putting in place. If we look at the statistics, it say we have the World Meteorological Organization report of 2023 with the United in Science report, which indicates that rather than having a decrease in fossil fuel emissions, from 2021 to 2023, we have actually had a global increase by 1%. So the mitigation efforts are really not working. The past 8 years are recorded as the warmest in history. In 2023 alone, there have been a number of natural environmental occurrences that have given rise to natural disasters. And I just list a few of them here. The wildfires that have occurred in Algeria and Tunisia and also in parts of North America are recorded as having been the longest in the history of mankind and also have increased greatly in intensity. And we know what happens with wildfires. You have CO2 emissions, you have further heating up of the environment, and all of that have they have their own consequential effects. We had the earthquake in Morocco in September. We had the floods in Libya, and all of these events have killed hundreds of thousands of people all over the world. Research shows that between 1970 and 2021, we have had about over 11,000 natural disasters that have caused 2 million deaths. 2 million people have died as a result of those natural disasters. And we have the global Earth has experienced about 4.3 trillion in economic losses. Now, unfortunately, and this is where our focus comes in, over 90% of those deaths, that's over 90% of the 2 million deaths, have occurred in developing economies, exacerbating poverty and inequality, and further amplifying food and water insecurity issues. Over 60% of the $4.3 trillion worth in economic losses have also been experienced in developing economies. And Africa being a developing continent and being the economies in Africa all being developing economies have been greatly impacted by these occurrences. So there's a disproportionate effect on vulnerable communities in the developing countries. The impacts of this extreme weather and climate change affect these communities and further undermine progress towards achieving the sustainable development goals that the global world is striving towards. Furthermore, the burden of poor and oftentimes, as we see currently, regressing political leadership on the continent does not lend any credence or any benefit to what is happening in terms of the impacts of climate change in Africa. and the raising conflicts and unrest. We have had in this year alone a number of coups happening in Africa. There is also the threat of the terrorist enclaves. We have Boko Haram in Nigeria that has been operating for quite a number of years. We have the Al-Shabaab and all of that. And these conflicts and unrests further amplify the effects of climate change that is experienced all over the continent. And so this brings us to the focus really of this paper, which is looking at the judiciary as one of the many agents for protecting the environment. And so just a broad overview is the fact that, we do have the African Charter, providing in Article 24 for the protection of the environment. And this provision has been adopted, in constitutions all over Africa. Some have been put as constitutional provisions. Some have just been, more of persuasive effect on the constitution or on the legal system of these countries. But generally, there has been an acknowledgement of the need to protect the environment. And so we're just going to be looking here particularly at the judiciary, the quasi-judicial bodies, and how they have adopted this very, very deliberate move to protect the environment. So the judiciary, as we know, is a very important branch of the governance system. It's oftentimes referred to as the last hope of the common man. The mandate of the judiciary is to ensure that laws are interpreted in a manner that upholds the law, while at the same time recognizing the context of those laws and making it a key component in guaranteeing the protection of the environment in this case. So the vital role of the judiciary was actually recognized as far back as 2002 at the UNEP Global Judges Symposium on Sustainable Development and the Role of Law. And this was happened alongside the World Summit of Sustainable Development in Johannesburg in 2002. And here it was observed that the judiciary, sensitive to its role and responsibilities in promoting the rule of law and environmentally friendly development, is essential for the realization of sustainable development. And from this, we have had a number of offshoots of regional attempts and regional focus by the judiciary on promoting environmental protection, equipping the members of the judiciary with the requisite knowledge, skills, and training to be environmentally aware, environmentally sensitive, to be able to interpret the law in a manner that actually ensures such protections to the environment. I just mentioned, there's the Asian Judges Symposium on Environmental Decision, which has morphed into the Asian Judges Network on the Environment. Within Africa, there is the African Judicial Education Network on environmental law. And the focus continues to be, focusing on the importance of the role of the judiciary in environmental protection. And part of what we have seen evolving has been from that awareness and from that consciousness is the creative and proactive judgments that are necessary, especially with the growing need to protect the global environment. And so the judiciary now has the responsibility of not just interpreting the black letter of the law, as I say in this paper, but actually adopting creative and proactive judgments that go further to ensure sustainable environmental protection, that in the face of developmental projects, that the environment and protection of the environment in a sustainable manner is actually key to those considerations. And so, as we know, it has been argued that the environmental issue, climate change issue, is actually an existential threat. And so this requires urgent and concerted efforts to ensure the protection of the environment. And just so we're going to just look quickly at some of the Evolving Jurisprudence, as this paper, the title of this paper indicates. So this is focusing on the African continent and some of the jurisprudence that we have had emerging. And so just to map out a trajectory of, how we're doing and how the judiciary has been doing. So the judiciary in Africa, and I'm just going to touch on cases. As you can see, some of the cases are listed here, just a cross-section of cases, some in the African continent. And so we had the era of the very rigid and restrictive interpretation of the law. And we saw that in certain cases that came through from Nigeria. I focus here on the Matai and Kenyan Times Media Trust case, wherein the High Court of Kenya actually refused to hear this case for lack of local standing. And just a quick background. So here the plaintiff, who was a very well-known environmentalist, not just in Kenya, but actually all over the world, Professor Matai had actually sought a temporary injunction restraining the Kenyan Times Media Trust Company from constructing, a new office complex in a recreational park in the center of Nairobi. And so the plaintiff had gone to court, to restrain the defendants from putting up this building. And what the Kenyan High Court decided here was that the plaintiff didn't have local standing to bring the case before it, because even though the plaintiff was a member of the very same community that was being threatened by this development, the court was of the view that there was no allegation of damage or anticipated damage or injury to the plaintiff, meaning that damage had not yet occurred. So in this rigid and restrictive interpretation, the view of the courts was that, well, it needed to wait for damage to occur, or there must be some allegation of damage before the defendants could then come to seek such injunction. And obviously, this was also against the backdrop that in the Kenyan law at that time, it was only the Attorney General that had the powers to institute public interest litigation. And so we had this era of very rigid and restrictive interpretation of the law when it came to environmental protection. So and so the courts were not sufficient or sufficiently handling cases of environmental protection. And of course, what happened then was that when national jurisdictions failed, or when plaintiffs did not get the desired result in national jurisdictions, then of course they went through to the regional bodies that had been empowered to hear such cases. And so we see in the cases, the SERAP case, the Center for Minorities' Right Development case in Kenya, that there was a gradual move towards engaging in this regional courts to be able to find the necessary answers that the plaintiffs sought. And so if we look at the SERAP case, and I put the years here just to help us to have an understanding of the progressions that happened. So in the SERAP case was in 1996. In this case, the Social and Economic Rights Action Center versus Nigeria, the NGO had gone, obviously having failed within the national jurisdiction, had gone before the African Commission. And in this case, the African Commission laid down an expansive interpretation of the duty of the state to protect the environment under Article 24 of the African Charter. And so this was the beginning of the evolution that we began to see taking place on the African continent when it came to environmental protections through jurisprudence. The next case, in the Center for Minorities' Rights Development case, the Commission further laid down the parameters for the participation and consultation of the people in decisions concerning their development. And so the Commission went further to say not just that there is a duty of the state to protect the environment, but the community that is being impacted by whatever development project needed to be consulted and needed to participate in that development process, in the decisions before, in the decisions during, and even afterwards. And the commission in this case really went into great detail as to what consultation and participation meant. And that actually laid down a framework for consultation and participation on the African continent. And so evolving from this minorities' right development case, we have the SERAP case in 2012. And here, this was a sub-regional court, the ECOWAS Court of Justice, which found that the Nigerian government failed to implement measures and failed to act to prevent or curtail environmental damage to the environment of the plaintiffs. And the interesting thing that the ECOWAS court did in this case was it didn't just award monetary damages as usually would have been the case, but the court rather opted for a collective benefit adequate to repair the collective harm that was suffered. And so what the court opted for here in terms of damages was that the plaintiffs needed to put back that environment. They needed to remedy the damage that had occurred to the environment. The court tried to focus on what would be done for the collective community that will stand as a form of reparation for the collective harm suffered by the community, and also for sustainable gain for future generations of that community that would come. So it was more about remedying the wrong, not through monetary compensation, but actually taking steps to heal, in quotes, the environment. So the next case that we see here, which fast forward to 2018, so we eventually in 2018 had the Center for Oil Pollution Watch and the NNPC. Now, this case I included here because it really marked a turning point when it comes to the interpretation of locus standi and the way the courts had, prior to this case, interpreted issues of locus standi. We had seen in the Mackay case that it was a very restrictive and rigid interpretation of the law. In this case, the Supreme Court of Nigeria actually granted the interdict that was being sought by the appellants in this case, for the purpose of, just restricting the development and the okay, I'm going to rephrase that. So the Supreme Court of Nigeria, while breaking away from that rigid interpretation of locus standi, broadened the scope to include any person that showed a bona fide interest in seeking the performance and enforcement of statutory functions and public laws. So basically, not only was there a requirement that such individual or such organization had to be directly impacted by whatever damage had occurred or whatever violations had occurred, but actually, locus standi was broadened that any person or any organization that had a genuine interest in seeking the performance and enforcement of statutory functions and public laws would have a right to approach the court to enforce those functions and to enforce public laws. And the court noted for the first time that due to the increasing concern for climate change and the depletion of the ozone layer, flooding and global warming, the Supreme Court noted that countries were adopting stronger measures to protect and safeguard the environment for the benefit of the present and the future generations. And it was based on this that the court indicated it had expanded the definition of locus standi, allowing the appellants to sue and to be successful in their suit. One thing of note that this court did also was to confirm the justiciability of environmental human rights in Nigeria for the very first time. Prior to this judgment of the court, even though Section 20 of the Nigerian Constitution provides a duty to protect the environment by the state, the courts had always interpreted that that duty was not justiciable because the section 20 was in chapter 2, which was actually a chapter that reflected fundamental objectives and aspirations of the state. And so the courts prior to this case had always interpreted that, well, you cannot come to court to enforce this section because these were just aspirational goals of the state. And so the Supreme Court radically changed the interpretation and confirmed the justiciability of environmental human rights for the very first time in Nigeria by this decision. It also recognized that the Constitution that guarantees the right to life in Section 33 implicitly includes and constitutes a fundamental right to a clean and healthy environment for all. So extending and bringing the right to life to include the right to a clean and healthy environment for all. So this was a very significant development that had occurred as a result of this judgment. If we move on, the last case here is the Wild Post case versus the Minister of Mineral Resources and Energy and others. This was a South African case where the appellants were actually successful in their interdict prohibiting the respondents from proceeding with the developments that had been sought in the Eastern Coast. And what had happened here was that the court found that the requirements, so the respondents had obviously argued that the appellants being an NGO did not have local standing to seek the order of injunction before it. But the High Court had found that the requirements for the interdict had been met, and that as long as there was a reasonable apprehension of irreparable harm to the environment, and then, there had to be measures that were taken to stop whatever steps would result in an adverse impact on climate and on the environment. And so this was just a cross-section of how we see the jurisprudence evolving over time. There are many more cases. There's a lot of jurisprudence coming through from Kenya also. In recent times, there is the development of in Kenya, actually, there is the environmental court, which is a dedicated court that deals with issues of environmental justice, environmental protection. And we see that happening all across the continent. So the awareness is there. There is the visible efforts and attempts at creative and proactive interpretation of the law. Of course, within the terms of the rule of law. So the courts do not go outside of their terms of reference, but find ways to creatively interpret the law to ensure protection of the environment. I'm just going to quickly, in the next slide, I had addressed other jurisdictions. And the reason for looking at other jurisdictions was really to see if there was more to learn and what was happening in other jurisdictions and ways in which we could perhaps find more things that the African jurisdictions could be doing to protect the environment. So looking here at the European courts, so we had the Betsky and others decision versus Ukraine. This was an European Court of Human Rights decision. And in this decision, what the court had said was that when it comes to environmental matters, it recognized that serious environmental risks will trigger various due diligence obligations on the part of the states, and so allowing access to individuals to independent review mechanisms. So where states were found to be wanting in enforcing and carrying out their duty to ensure environmental protection, individuals were allowed access to approach different independent review mechanisms. And the court here drew the link between environmental protection and the health rights of people, and concluded that the hazardous state of the environment would negatively affect the health of the human population. And so the court also here restrained the states from the development that had been already sought. The next case, the Uganda Foundation case versus the state of Netherlands. Also, this was a national decision by the Hague District Court, where it had ruled that it was unlawful and illegal for the defendants not to reduce the annual greenhouse emissions by at least 25 to 40% by 2030. And this case is discussed here because it was really, really very interesting to see the court going beyond even the emissions target that the states of Netherlands had already signed to in the different international treaties that it had ratified. And so the states of Netherlands had already ratified, the various environmental protection treaties and had indicated that it would reduce its emissions targets by 25% by 2030. But based on, so what this court had done was that due to the pressing need, the court had looked at the global situation when it comes to climate change and looked at the state of Netherlands as itself and the obligations and what the state could do further over and beyond its international law obligations. And so the court had said that, it would be unlawful, and that was the word that was used, for the state not to reduce its annual greenhouse emissions by way above that 25% that it had indicated by 2030. So even though those percentages were way above the global emissions scale that the state had subscribed to, the state was not in breach of its emissions target, but the court held that it had a duty of care to mitigate harms to the climate and to prevent dangerous climate change. And so here we see the court taking a proactive and even a preemptive stance, considering the dire state of the global climate. And so this was a very instructive case that the Netherlands had dealt with. And it obviously provided precedent for other cases that have come before the court. A quick look at the Asian region, and I just looked at two cases from that region. India in particular has been a very big contributor when it comes to global environmental jurisprudence. We have seen a lot of developments in India concerning environmental protection, a lot of institutional developments also. So in the first case in India, a 2019 case, the Supreme Court here suspended clearance for the development for an airport in the state of Goa and ordered that the government needed to revisit the clearance certificate that had been issued because it had failed to take into account environmental impacts on the environment. So the government had failed to take into account the impacts that the construction of that airport would have on the environment. And so the court here had suspended the issuance of that clearance certificate until the state had gone to do its proper jurisprudence and then its proper impact assessment, and then came back. And it was only at that point that the Supreme Court lifted that suspension. So we saw the Supreme Court being, very hands-on, suspending the issuance of the certificate until such a time and ensuring that the state did its proper impact assessment and came back. And it was only at that point that clearance certificate was actually reissued. In 2012, also, we have the second case of Hindustan's Zinc and Rajasthan Electricity Regulation Commission. And here also, the electricity regulatory body had sought to introduce renewable energy, and it was a gradual introduction. But what the regulations had required of existing electricity providing companies was that they needed to purchase renewable energy. So even though they were companies that had been legally authorized to provide, private companies that were providing the electricity, but then the regulations require that they needed by compulsion to purchase a certain portion of renewable energy. And so these companies had approached the courts. And when it got to the Supreme Court held that, well, while these companies did have a legal and valid right to provide electricity, on a private basis, but the court considered that looking at the global economy and looking at the larger public interest and the need for a clean environment, that renewable energy was something that needed to be promoted, was something that the state needed to promote. And as a result, it held that it was in line for the states to enforce the compulsory purchase of renewable energy, just to ensure that there was a rollout of renewable energy to the population at large. The court held that this was in line with India's domestic and international obligations. And so, like I said earlier, so we see here the courts in Asia, the Supreme Court in particular, but not just the Supreme Court, there are quite a number of cases that have come before other lower jurisdictions that have actually been very particular in promoting anything or any kind of measures that will involve environmental protection and at the same time the development, sustainable development within those jurisdictions. And I just put here, and I will be just, before we go to the conclusion, just a quick look at certain measures that we see occurring in North America. And it actually will take us back to the ECOWAS case that I had mentioned earlier. So the issue of creative sentencing, is one that has now, is the courts are looking at in terms of going beyond just, finding that there has been a breach of environmental protection measures, but also finding creative ways to ensure that whatever kind of damages, whatever kind of punitive measures it orders will actually help to restore the environment. And so in certain jurisdictions, in Canada in particular, creative sentencing has been adopted in environmental protection cases. And this is seen as a way to give allowance for judicial extension of the ambit of environmental protection from merely deciding on the rightfulness or wrongfulness of an action, and as a result imposing a fine, as is the usual practice, to seeking ways in which the punishment that is imposed is such that seeks to repair the damage that is caused either directly or indirectly, and also seeking ways to put in measures to forestall future damages or breach of the environment. And so what we have seen in these cases is that where there has been a breach and the court finds that there has been a breach, the party at fault would be ordered possibly to pay a fine, but the fine is specific to an organization that is involved in environmental restoration within that geographical location. And so it's more like the party at fault will pay a fine to fund the activities of such an organization that is involved in environmental protection measures within that geographical location. So more of the damage has been caused, the party is found guilty, the party now has to take measures to restore the environment within that geographical location. And if we look back at the ECOWAS case that I mentioned earlier, it was also something that we saw that the ECOWAS court had done, not just to impose a fine, but to ensure that there was a collective relief to that community. Because many times in certain cases, when a fine is imposed and it is paid, and then the damage is never remedied, and then the money disappears into certain pockets, but then the damage to the environment persists. And so this creative sentencing is one that is necessary, I think that should also be looked at by African jurisdictions. And that brings us to the conclusion. And just a few words quickly to conclude. I see it's, my time is getting fast spent here. So the role of the judiciary in environmental protection cannot be overemphasized. I think that is clear, and that is something that we would all agree to. In delivering justice, the judiciary needs to deliver real justice. Judges have the capacity to use their interpretative mandates to deliver real justice. Where judges are able to adopt creative and proactive stance, it advances jurisprudence in the field of environmental law, thus also ensuring a furtherance of an environmental rule of law within the African continent. It ensures protection of the environment in the face of executive and legislative arms of government that might be, derelict in their responsibility to protect the environment. And that also has a consequential effect of mitigating climate change. There is a need, even as we have seen from the other jurisdictions explored briefly, that African judges, there's a greater impetus that African judges need to apply towards creative and proactive reasoning in environmental protection cases. Judiciaries are finding ways to break away from the constraints imposed by Black letter law to achieve the goal of environmental protection, and African judiciaries must not be left behind in this goal. Thank you so much. I think that brings me to the end of this talk today. Thank you all.
Thank you so much for that insightful presentation. It's so good to see what we are doing in Africa as well, and the judiciary indeed plays such an important role. I'm going to open the floor for questions. You participants can raise their hands or type in the chat. Does anyone have a question so long? Perhaps while people think of a question, I will start. So I found the presentation fascinating, and I was wondering, unless I missed it, whether the courts in any of their decisions, the African courts particularly, spoke about or alluded to environmental rule of law in Africa, and what that might be in our African perspective. And what perhaps in your view you think other courts and regional courts perhaps can learn from what the court is doing in the African context.
Thank you, Angela. So just looking at a broad view of the jurisprudence that we have seen, and that's why I kind of looked at the evolving nature of the jurisprudence in Africa. And so the courts have not yet gotten to a stage of identifying an environmental rule of law. There has been a lot of literature that has been written, about this, because when we look at all the protection mechanisms that we have had, and we do have a ample, I must say, within the African continent when it comes to different types of governance bodies and protection mechanisms. So it is argued that there is an emerging environmental rule of law in Africa to ensure the protection of the environment. But I think that, as we have seen, the courts tend to catch up on these things. It takes a while for the courts to catch up on these things. The second aspect of your question was, looking at what were you asking about what other jurisdictions could learn from the jurisprudence in African courts?
Yeah, particularly the European Union. I think last week there was an interesting ruling about environmental rights by the European Court of Human Rights. And, we're always saying, literature tends to look at westernized countries and laws to draw lessons. But what would you think, or what would you say, can a court system like the European courts learn from us, or what we're doing in Africa?
And that's great. That's a great question. And it's actually something that I have, addressed in another paper entirely. And I think there are two main things that we have to offer to the global environment, especially looking at the jurisprudence that has come from the African Commission in particular. So there is the identification, and possibly because of the fact that Africa works on a collective rights basis. When we talk about the people, we talk about the African Charter itself identifies the peoples, and so there's that identification of collectivism when it comes to the enforcement of rights. And this is something that the African Commission has actually reiterated in the minorities' rights case, and I think it was also either in the SERAP or the SERAC case itself, the collective nature of the rights when it comes to environmental protection. And so moving away from the individualism that we see in the West, when it comes to issues of environmental protection, that's something that Africa definitely is offering the global world. The other thing is the way in which the African Commission in the minorities' rights case actually broke down the issues of what consultation and participation means. I mean, there was a very extensive decision by the African Commission that actually is precedent, in terms of what is the nature of consultation and participation that is required when it comes to issues of environmental jurisprudence.
Thank you so much. I think we might have a question from Dr. Ashakim, and then there is one in the chat as well that I'll read. But Dr. Ashakim, you can go ahead.
Yeah. Thank you so much, Professor Familola, for this excellent presentation. Can you hear me?
I can.
Oh, okay. My question relates to the tension between environmental protection and economic development. I would like to know your thought about whether you think that the court has been effective in strengthening environmental protection through environmental rule of law in that context. And because we know in certain cases, the court has vehemently disregarded environmental protection in favor of economic development. What then do you have to say about the mandate of the courts to overhaul environmental protection?
Thank you so much, Doc. Yes, that is really, I think that's a conundrum that the courts find themselves many times. And as you say, the courts, especially within the African jurisdiction, and possibly because of the fact that it is a developing region, and there is therefore greater impetus for developmental projects, funding from the global north that comes through for developmental projects. So the courts have, historically favored developmental projects to the detriment of environmental protection. But I think what we see emerging and is that there is, due to the awareness of our courts, due to the awareness of the members of the judiciary, our judges, a lot of training, a lot of has happened over the past years, especially since 2002, the Sustainable Development Goals, and there's been a lot that has happened. So we find that the courts are trying to strike that balance now. And the recent jurisprudence, I mentioned I think it was the NGO, the case in South Africa, where the High Court actually suspended, and that's not the only case, actually. There are quite a number of cases within the South African legal system where the courts have stepped in to either suspend or actually to stop development. Steps would have been taken by the executive, the ministers in question, to grant certain developments. And once there's agitation, NGOs go to courts, public interest litigation happens, and then we see the courts actually taking a look at the parameters of whatever approvals have been granted, and trying to balance that against environmental protection requirements. That's the same thing that we see in the Supreme Court case, the 2018 Supreme Court case in Nigeria, where it's taking that Supreme Court, I mean, about 2 decades really, to come to the decision in 2018 of broadening, local standard provisions or requirements to allow such kinds of jurisprudence. So what I think is that there is hope. There is an emerging jurisprudence that we see. We can see that the courts are more aware, and with this awareness, the courts are actually now taking steps to ease that tension and to decide in favor of the environment. Thank you.
Thank you. I see we have 2 questions in the chat. So one is from Mark Odaiga. How might courts strike the balance between environmental protection and the right to development? This is particularly problematic where courts seem hesitant in halting, even temporarily, projects which might harm the environment. The result is judgments which are progressive, but sometimes come after projects are concluded and have already harmed the environment. There is another question, 2 more questions if you'd like me to read them.
Well, I do see them. I don't know if you want me to just answer, or you probably want to read them out. I don't know.
Yeah, just I guess for everyone else. So from Dominique, we have, thank you for the presentation. How can we solve climate-induced displacement leading to climate refugees from an Afrocentric point of view, taking into account an inadequacy of protection in international and national laws? That's a very important question. And then from Justin, how can courts progressively use environmental provisions to enhance climate justice? So 3 really key questions, important questions there.
Thanks so much, Angela. So just to take the first question, and I think it's quite similar to the question that I had just answered in terms of, striking that balance between environmental protection and the right to development. And basically it's what I have said, and a number of other writers have actually commented on, is the fact that, it's that Africa is a continent where we have a very active regional organization when it comes to lawmaking, when it comes to having charters and conventions and treaties and all of that signed. But when it comes to the enforcement, that is where, we find ourselves struggling quite a bit. But I would say that the courts have actually, are slowly being more proactive in ensuring that there's a balance. At least what we are seeing is that there is now an awareness, a sensitization by the courts, by the judiciary in Africa, of the need for environmental protection. There is an acknowledgement in many judgments, that have to do with the environment. There is an acknowledgement by the courts of the urgency to ensure environmental protection. And so I would, look that in the future, we will see more and more cases that will be decided, that would actually favor protection of the environment. It's a very fine balance, because Africa is also a continent that is in need of development, in need of developmental projects. Without development, issues of poverty cannot be resolved. Even issues of climate change, mitigating the effects of climate change will not be resolved without development. So it's a fine balance, but I would say that the courts are on the right track. The second question from Dominic talks about solving climate-induced displacement leading to climate refugees from an Afrocentric point of view. And that is, so when we talk about displacement, generally, unfortunately, our continent is also one that, houses, the largest or highest number of displaced people, even living within the continent itself, much less the numbers that we see actually going to the west. So there's a lot of displacement that happens even within Africa itself. And I think, what my paper, focused on in terms of creative and proactive measures by the courts, by the judiciary, by quasi-judicial bodies to protect the environment is something that would actually be able to assist in this case. But we also need to bear in mind that the courts will only deal with matters that have brought before them. So we also need to look at issues of access to justice. What are those constraints that continually limit people, citizens being able to access the courts to be able to get the kinds of relief that they seek? And so these are, different ways in which we can begin to look at stemming the tide of climate induced refugees. The issue of climate change is one that is here to stay. The fact that the consequences of climate change will continue to happen is a truth. And the fact that we will continue to have climate refugees is a fact. So it's a case of looking at ways to stem the tide of that. And I think, the proactive and creative stance of the courts and the more of those stance will actually be able to help. I think the second question is the same thing. How can the courts progressively use environmental provisions to advance climate justice? I think that's really the essence of of the paper here. That if the courts are sensitized and aware of the need for climate justice or environmental protection, then the judgments of the courts would actually, show that level of sensitization. The issues of collective reparations or creative sentencing, as is said in some other jurisdictions, is very important, because apart from just being able to, the courts just awarding damages, which has been done. I mean, in many of the Shell cases that have, we've had coming out from Nigeria in particular, and where the Nigerian jurisdiction has failed or the legal system failed, and many of those cases have gone to the UK, have gone to the Netherlands, which is the home of Shell itself. What we see being done in those cases is that, the fight for climate justice is being taken away from places where it's been restricted to places where there is more of an opportunity for relief. And the even though I know that there was a judgment, I think a 2021 judgment by the UK Supreme Court recently. I think it's the Jala versus Shell case. I'll look for the full title of that actually was a retrogressive judgment that restricted, because it held that the appellants did not have, the issue of local standing again in that case. But we have seen other cases where there has been awards, monetary damages, where Shell has been found guilty of damage to the environment. There has been monetary compensation, but we have not seen the effects of the compensation, because the relief was not targeted at repairing the environment. And that's something that I think is really important that our courts need to look at to advance climate justice. So that is something that I would suggest in terms of answering that decision. I think that's all the questions, Angela.
Yes, that was. I'm not sure if anyone else from the audience wanted to sneak in a last question. All right, then we finished precisely on time today. Thank you everyone for attending, and Dr. Abuye, thank you again for waking up so early. For those of you who don't know, she is in Canada, and it was 5 a.m. in the morning for her when we started. So thank you so much for joining us. I really appreciate it. All right, wait, there is a question from David King. My question is, what about the difference between precautionary principle and polluter pays principle? If you want to answer that in brief.
Thank you so much, David. Yes. So I think, you see, this is also part of, finding that balance. So the precautionary principle, if we take it in the context of creative and proactive interpretation of the law, which is what, we are now advocating that our courts need to adopt, then the courts would make sure that in interpreting this principle or applying it to any case that comes before it, that it ensures that even before, and I think that was one of the questions of that I saw earlier, that was one of the points that was made, the fact that a lot of these cases only get to the courts after the damage has already occurred. And so there is no way to prevent the damage that occurs. And that goes back to the issue of access to justice, and also actually ensuring the awareness, not just on the part of the judiciary, but also on the part of the citizenry as to their role in protecting their environment and being aware. So in terms of, walking this fine line and looking at the difference between these two principles, the issue of proactive and creative interpretation is still applicable, because when cases then get to the courts is able to look at and find that balance in applying. The polluter pays principle, yes. The polluter would pay, but what happens? What kind of payments are we looking at when we talk about the polluter pays? Creative sentencing, or the kind of sentencing that we saw in the ECOWAS case, is one that would ensure that that payment is directed at ensuring a restoration of the environment, a restoration of the damage, mitigating the effects of that damage to the environment. So these are, so the principles are there, but it's just how do we ensure that we interpret them and apply them in a way that deals with the urgency that is experienced now, the global urgency when it comes to issues of climate change. Thank you.
All right, thank you so much. And as I was saying, thank you again, Dr. Bouye, for joining us from so far and so early. We really appreciate it, and it was great to have you. I hope to have you again soon, and I will keep an eye out for your research. Thank you, everyone, for joining. We will make the recording available soon. And Dr. Bouye, there was a request for your slides. So if you could perhaps email them to us, and we'll also make that available. But thank you, everyone, and have a great week.
Thank you. Thank you so much for having me. Thank you, everyone.